setting up.
We ready?
Just give me a couple of seconds. And yes, we are ready. All right.
All right. Well, good afternoon, everyone, and thank you for joining us today. My apologies. I don't know what's going on with my camera, but my name is Cecile Carlson, and I'm with the City of Houston Department of Neighborhoods. We are part of Month of Service collaboration, and together with our partners, we bring valuable resources and information to the community. Today's presentation is focused on clear titles. We're going to talk about why they matter and the ways that you can protect your property. Um, Property ownership is one of the most important ways to build and maintain generational wealth, but when we don't have these issues resolved, they can create very serious challenges. And so that's why we're here to help you understand the importance of having a clear title and the steps that you can take to protect your home and your assets. We're excited to have our presenters today, Ms. Lisa Nelson from Texas Legal Services, Ms. Mabel Menfee from HCAD, and Ms. Shea from the Harris County Tax Assessor's Collector's Office. That's a mouthful. They will be joining us today to provide us expert insights on this topic. As always, we encourage you to ask questions and engage with us throughout the presentation. You can type the questions in the chat or send them privately. You can also email them to us if you prefer. Just keep in mind that this presentation is for for educational purposes only, and we're not giving out any legal advice. If you have any questions that have a lot of personal details, please just be mindful that this is being shared in live stream, and that information will be seen by other participants. So just be mindful of that when you are asking questions. But if you need any personalized assistance, we encourage you to reach out to our legal partners. In addition to this Zoom session, we're also live streaming on Facebook and YouTube. So if you find this information helpful, which I'm pretty sure you will, please feel free to share the recordings with others and let them know that we're here on a monthly basis bringing education to the community. So I'm going to go ahead and not take up too much time and let our presenters get started. And thank you, everybody, for being here.
Mabel and Shay, do you want to introduce yourself first, and then I can go ahead into this presentation?
Sure, I'll go ahead. Well, I'll go ahead and start, and then if that's okay, if Shay is let's follow. Hi, am I on here? Let me just am I on?
You're on.
I can hear you.
Oh, okay, great. Can you see me?
Yes.
Oh, perfect. Good afternoon, everyone. My name is Mabel Menifee, and I'm with the Harris Central Appraisal District. And I'm here today to sort of help flesh out some of the details that Lisa is going to talk to you about as it relates to clearing title on inherited property. There are always a number of questions surrounding exemptions and the role that the appraisal district plays in that process. So I'm going to have a brief presentation to follow up on with information about that.
Awesome. Hi, everyone. My name is Shay Pinkowski. I'm with the Office of Annette Ramirez, who is our Harris County Tax Assessor Collector. And I am here to help explain some of the ins and outs of our billing processes, how bills work, and ways that we can assist you with making sure that your tax bills get paid this year and every year forward. If you have any questions, I'm happy to help and assist. We are going to have some assistance in the chat, so please feel free to put some questions in there. And worst case scenario, I will be able to answer them a little bit later on during the presentation. But thank you so much for joining us. I'm really excited to be able to share some information with y'all today.
Good afternoon, everyone. My name is Lisa Nelson with the Texas Legal Service Center. I'm going to get into my presentation, and I'm here on my own, but I will be monitoring the chat after my presentation is done, and I'll be able to answer your questions when all three of us are done. After our slideshow, we'll have plenty of time for Q&A. Okay, I'm here today to talk about clearing title and other probate concerns. This special focus is on how to handle inherited property. I'll give a quick overview of the probate system, and then we'll discuss how to clear title when you've inherited property and how to make sure that your heirs don't have that problem going forward. And then I'll pass it over to Mabel and Shay to talk about property tax issues. I'm with Texas Legal Service Center. We've been around since 1981. We're a statewide organization that provides advice, advocacy, representation, and education to underserved people across the state. We have more than a dozen practice areas that touch almost every aspect of civil law that affects low-income Texans. So there's a lot of new vocabulary to learn when you're dealing with probate. A decedent is another name for a person who died. Testate is a person who died without a will. Intestate is a person who died without leaving a will. And a testator is the name for the person who has a will. When you sign a will, you're considered to be the testator. And a will is a legal document which states how the testator's property is to be distributed at death. Estate is your stuff. It's both your real and personal property that you own as of the time of death. And probate is a technical term that's the court process of winding up a person's affairs. The probate courts, if you're in Harris County, Fort Bend County, actually Harris County, Galveston County, and some of the other larger counties in the state, we do have our own probate courts. Otherwise, it's handled by the county courts of law. That is the court process is considered probate, but if someone passes without a will, it's called an administration. There were several names for the person who is responsible for wrapping up your affairs. If there's a will, they're known as an executor. If there is no will, they're known as an administrator. And in both of those situations, it's the personal representative of the estate. Heir and beneficiary are names for the person who inherits either through a will or by Texas law. There's a lot of common mistakes when someone passes away. A lot of people think it's okay if there's no will because they had a power of attorney. Once someone has passed, powers of attorney are void. They are no longer valid as of the moment of death. A lot of people think that because Texas is a community property state, that if you're married, you have a right to that house. If it's separate property, you have a right to stay in the house for the rest of your life, but you do not have a permanent right to that house. You're allowed to stay in the home for the rest of your life, and you must pay the property taxes and pay for maintenance. However, you own that property with any children from another relationship. An executor or an administrator of the estate, and again, an executor is someone you name in the will to wrap up your affairs. An administrator is a person who is appointed by the court to wrap up a person's affairs. They cannot serve if they're under the age of 18 or they live outside of the state of Texas. Most important thing to determine once someone passes away is if they have a valid will. One thing that's really critical, if you have a will, you need to let your executor and someone else that you trust know where your original will is. If they cannot find the original will, Texas law presumes that the will was revoked. Now, Texas is pretty flexible with allowing people to prepare their own wills, but I highly recommend having an attorney prepare a will or at least review your will. AMOS has partners who do pretty regular will clinics, so I recommend keeping your eye open because for most those clinics are free of charge to Texas residents. I cannot recommend forms that you get off the internet, such as LegalZoom. Those have been written to be as general as possible and be not comply with any state laws. So although the will might be okay, If it's not compliant with Texas laws, it will be much harder for your family to probate that will. On my office has a website. I'm part of the team for texaslawhelp.org, and we do have forms that the Texas Supreme Court has approved. So you can go to our website and use our forms to prepare your own will. Spouses need to have separate wills. You cannot have one will for a married couple. Texas does allow you to handwrite your wills. It's known as a holographic will. We have information on our website, texaslawhelp.org. Our partner at Lone Star Legal Aid also gives a presentation that's the basics of how to set up your own estate plan. And you want to be sure to have your will in a safe place where your loved ones can find it. A lot of people may put it in a safe deposit box. If you do that, you need to let the financial institution know that someone has permission to access your safe. If they don't have permission in writing at the bank cannot legally allow them to get your will out of the safe deposit box. A lot of people think, well, my family gets along. I don't need to worry about this. If you die without a legally valid will, the law determines who inherits your property, not who you would wish to inherit your property. If you cannot find a will, your attorney can file an application for administration. And what I forgot to mention, in Texas, when you go through the probate process, you have to have an attorney. The reason is probate is pretty straightforward in Texas. It's much simpler than it is in a lot of other states, but there's still different nuances to the law. And it's important to consult with an attorney because they can determine the best way to proceed. And this is especially critical if you cannot find a will. If there is no will or the will is not legally valid, you can file an application for administration. Depending on the circumstances, you'll either file for dependent or independent administration. There are extremely limited cases where you can file a small estate affidavit. Probate assets are property in the testator's name that pass under a will. This would include your real estate and your personal property. That would be your household items, your furniture, your car, your clothes, all of those things. Non-probate assets do not pass under a will. They pass in accordance with the terms of a contract. So for example, anything that someone would inherit from life insurance or retirement plans, those pass according to the beneficiaries named in your life insurance and retirement policies. Also, all of your financial accounts can have what is known as a payable on death or transfer on death beneficiary. That allows people to inherit those funds very quickly and easily, as opposed to having to go through the probate process. If you learn nothing else today, I think it's great to learn that if you have payable on death beneficiaries on all of your financial accounts and a transfer on death deed for your home, your family may not need to probate your will. Now, I'm not saying you shouldn't have a will. You should always have a will because there's a chance that there's something out there that you've forgotten about. But I recommend this afternoon after we meet or tomorrow that you call your financial institutions and make sure that you have payable on death beneficiaries. Small estate affidavits confuse a lot of people because in most counties in Texas, you do not need to have an attorney. So a lot of people think, well, that's what I use if my loved one didn't have a will. You can only use a small estate affidavit in very limited circumstances. For instance, you can only use the small estate affidavit to transfer real property if it's a surviving spouse or a minor child that inherits the home. If you have adult children, even if they lived with you in the home, they cannot inherit the house through a small estate affidavit. It only applies to surviving spouses and minor children. When you use a small estate affidavit, all heirs have to agree. They all have to sign that affidavit before it is filed with the court, and you also have to have 2 disinterested witnesses. Those are 2 people who knew your family history well but do not legally inherit from you. You cannot use a small estate affidavit if the person did not leave if the person left a legally valid will. So even if it's a simple small estate, this procedure is not available to you if you had a will. The value of the estate has to be greater than its debts. So for example, if you have an estate that excluding your home is valued at $30,000, but you have $50,000 in debts, the judge will not approve a small estate affidavit. Also, the estate has to be less than $75,000. It's important to remember that the value of your homestead is not included in the value of the estate, but besides that, you still have to have the value of the assets greater than the debts. And the debts do include any mortgages or home loans. So say your estate is valued at less than $75,000, but you still have a mortgage or some other type of home loan that's more than the value of your estate. This procedure is not available to you. In both probate of a will or independent administration, the procedures are similar. What happens first is your attorney begins the process by filing an application. If there's a will, it's called the application for probate. If there's no will, it's an application for independent administration. It has to be on file at the courthouse for 10 days before the attorney can schedule a court hearing. Do not think that this means you'll go to court that quickly. In Harris County, you're looking at 6 months or more. The courts are just that backed up. We don't have enough courts to handle all of the business. The judge will determine, in the case of a will, if the judge determines that the will is legally valid, or if the judge determines that the independent administration is a good application, the judge will appoint a personal representative. That personal representative receives letters. They're either letters testamentary, if you're probating a will, or letters of administration if it's an administration. That personal representative is responsible for gathering all of the estate assets. They have to get a tax ID number and open a bank account for the estate. So any bank account that a person had before they passed, all of that would be transferred to the estate's bank account, and that remains open to pay any bills due by the deceased person and collect any money that was due. You do not ever think that you are responsible for the debts of a deceased loved one. You are not. They only get paid out of the funds of the estate. So the attorney notifies any creditors of the estate, and the creditors have to file a very strict legal process. They have to use certain language. If they don't use certain magic words, those debts are not valid. So you want to have the attorney carefully review that. Don't just start paying those bills yourself. The attorney and the personal representative file an inventory. The inventory is a list of all assets as of the date of death. The judge would then approve that inventory, and you can close the estate and proceed to distribute the property. When I worked at Earl Carl, a great deal of our work was clearing title to inherited homes. Quite often, people mistakenly think that if it's a home that's been in the family, all it has to do is stay in the family in order for it to be properly owned. It's far more complicated. So if you live in a family home, it's critical to have clear title. If you don't have clear title, you don't qualify for local, state, or federal assistance if there's a natural disaster. So when we have our next hurricane or next winter storm, next derecho, we can keep naming the disasters we have here in Houston, and you need to apply for assistance from the county or assistance from FEMA, they cannot legally give you any aid if you don't have clear title. And that's a bad time to find out that you don't have clear title, because then you've got to rush to get the title cleaned up before you can get that money to help you rebuild. Also, and this is why I have my friends from the Central Appraisal District and the Tax Assessor's Office. In order to get your correct property tax exemptions or deferrals, you need to be the owner of record. You're not eligible for homestead taxes, for homestead exemptions until your title is clear. So now you're probably wondering what clear title means. A clear title means that nobody else has a financial interest in your property. It means there's no question of ownership and that someone could go to the county property records and easily trace the ownership history of a property. If the property isn't legally transferred to the new owner, you have what is called a cloudy title. This usually happens if somebody dies without a will and the family does not manage the estate. Now, a lot of times when I used to do title work, I would get a clear title and my client would ask me, well, where's my deed? Those are two different things. A title is the legal right to the property. It's not a piece of paper. It's just you are the true and correct owner of this property. Deed is the written statement that conveys that you have that legal right to the property. So a real estate title is not a document. It's how strong your ownership claim is. And having clear title means that there won't be any unexpected claims on the property. You won't find out later that, say, there's a lien on your property from from years ago. Deed is the document that transfers ownership to the new owner. Like I said earlier, it's really important to have clear title so that you have access to disaster recovery assistance, property tax relief, home improvements, and loans. If you try to apply for those things and do not have clear title, you will find out quickly. And people get concerned about keeping their title clear. The easiest way to keep your title clear is to file a transfer on death deed. That's the easiest and least expensive way to transfer real estate to somebody after you pass away. You can also use a legally valid will to transfer property after you die. And I run into this all the time where people just think that houses and other things just automatically pass to the surviving family members. No, you have to go through legal processes to transfer that. If you do not probate your loved one's estate in whatever way is appropriate for them, you may not have clear title for any real property, and you probably won't be able to access any financial accounts. The most typical way to clear title is through the courts. If the homeowner has passed within the last 4 years, you should file a probate application or an application for administration. If it's been more than 4 years, you can file an application to probate a will as a muniment of title. That's a complicated phrase that basically means, Judge, the only thing I need to do is transfer the house to the person named in the will. There is nothing else that I need to wrap up in this person's affairs. Your other option, if you meet the requirements, is to file a petition for adverse possession. Traditional probate, I discussed briefly before. The easiest way is to probate an estate within 4 years of the date of death. This is where the judge determines if the will is compliant with Texas law. And like I said, if the person did not leave a will, you can file an application for administration. If it's been more than 4 years, you can file an application for probate as muniment of title. The will has to be legally valid. All heirs have to agree to probate that will. And once the judge admits the will to probate, you're done. Your attorney just has to record the signed order and the will and the property records, and the property will have been transferred. Adverse possession is something that you've probably all heard of. It's a legal principle that says that a person can obtain legal ownership if a property, as long as they've continuously occupied the land for a specific period of time. There's several different Texas statutes that list what the time periods are. It's typically about 15 years, but it does vary based on your circumstances. One of the most critical things about adverse possession, if you notice that term adverse is in the title, you cannot get property this way if you have permission to live there. So I've had situations where my client was allowed to live in the property. Everybody in the family agreed that she could live there, but they were not going to sign the title over to her. She could not use adverse possession because she was not living there adversely. Everybody gave her permission to reside at that property. There's a very simple way to prepare to clear title without going through the court process, so that's a lot quicker. There's an affidavit of heirship. That is something you can absolutely do on your own. You don't need an attorney. You can find a form with instructions at our website, texaslawhelp.org. An affidavit of heirship is a legal document that gives property to the heirs of a deceased owner. It may be needed if the homeowner did not have a will or the will was not probated within 4 years. Now, one thing that you need to know, affidavit of heirship gives the property to all legal heirs, not just one person. What you have to do, you have to find 2 witnesses who knew the deceased person and their family history. Like the small estate affidavit, they have to be disinterested witnesses. That is, they do not legally inherit. You have to include the full legal description, which is found on a deed. The legal description listed on your property tax bill is not a full legal description, and it will result in a cloudy title. You have to file the affidavit of heirship in the county where the property is located. There is a filing fee that varies by county. I can promise you it's significantly less expensive than going to probate court. I'm going to say it's roughly $50. It can be a little bit less. The fees are slightly higher in Harris County than the adjoining counties. A lot of people get the small estate affidavit and affidavit of heirship confused. I understand they both have affidavit in the title. Small estate affidavit can only be used to transfer real property to a surviving spouse or children under the age of 18. Now, if the loved one did not have a home and you only need to transfer, for example, a bank account, check with your bank first. Often, a bank will allow you to use a small estate affidavit to transfer those assets to the beneficiaries. Affidavit of heirship is the best way to transfer a home to either a surviving spouse, adult children, or other transferees. To nieces, to nephews, to whoever legally would inherit from you. You can use an affidavit of heirship instead of going through the probate process if the home is the only estate asset. After I would clear title for my clients, I'd say, let's make sure that your family doesn't go through this. Let's keep this in the family moving forward. One of the best things that Texas did maybe 5 years ago is a transfer, no more than 5, maybe less than 10 years ago, Texas is allowed a transfer on death deed. And that's a simple way for a homeowner to transfer a home or real estate to someone once they have passed away. A transfer on death deed does not affect the owner's rights during their lifetime, so the owner can still sell the property, use the property as collateral for a loan. They still qualify for their property tax exemptions, etc. And the beneficiary has absolutely no rights until after the owner passes away. The beneficiary is just there, named as the person who inherits once someone passes away. As the owner, you can change the beneficiary of your transfer on death deed. You can also just cancel it entirely. And the deed is no good unless you file it in the county where the real property is located before you pass away. We have a transfer on death toolkit at our website, which provides you with detailed instructions and a form to fill out that you can take to record at the clerk's office. You want to be sure to find an existing deed to get the correct legal description. If you can't locate a deed, that's okay. You can call the clerk's office. There are also some places online that you can order your deed and locate the full legal description. One of the great things about a transfer on death deed, besides transferring the home to whoever you wish right away, is it protects your property from Medicaid estate recovery. Most of us will use Medicaid to pay for nursing home care in the future. Once someone and their surviving spouse have passed away, Medicaid can seek to be reimbursed for their expenses. The only way that Medicaid can seek reimbursement is through the probate process. So if you transfer a home through a transfer on death deed, Medicaid is out of luck, and it's fabulous for your heirs because they now own your home. We have a lot of great partners. My office manages the Texas Law Help website. We also provide advice. Attorneys are available 10 to 2 Monday through Thursday. We can give legal information to anyone who lives in the state. Legal advice depends on your income. And if you need direct legal representation, there's Earl Carl Property Preservation, Lone Star Legal Aid, Houston Volunteer Lawyers. Those all provide free legal representation. Legal Line will provide free legal advice to anyone that's not income based. And Houston Lawyer Referral Service is a great place to locate your own lawyer. They also have programs for people who cannot afford a lawyer's typical rates, and those lawyers guarantee that they will charge a lower rate to people who qualify. Thank you very much. I'm going to pass it over to Mabel at Harris Central Appraisal District, and I'll be here afterwards to answer questions.
Thank you, Lisa. And I am now sharing my screen. All right. All right, can you all see that now?
Yes.
Okay, I'm trying to get rid of the sides of it. But again, good afternoon, everyone. My name is Mabel Menifee, and I'm with the Harris Central Appraisal District. And I'm going to kind of fill in the blanks for you today. That's on some of the things that Lisa talked about as it relates to exemptions in particular, and clearing title for on your property. And in many cases, exemptions do have a lot to do with that. Once again, I'm sorry to ask again, just want to make sure you all can see my slides. Is that correct?
Yes, we see
Okay.
the first one.
Okay. So
Mabel, you need to switch to the slideshow view.
okay.
That one.
Because it needs to be saved in the cloud first, which I really don't understand.
Computers always do it at the wrong time.
From the beginning. Let's see. I know we had it up just a minute ago. Short time ago. Okay, so let's see this. My apologies, folks. We have a stubborn system in our building because of all the security, but let's see. Anyway, how much of it is showing?
It's in the regular PowerPoint screen, so it
Mhm.
has all the background stuff.
Right, and that's what I was trying to get rid of. Let's see. That is there, and
Can you go to that next one that says slideshow? Keep going, then one more over.
One more to your right.
right, and now it comes down. Let's try it from current slide. From the beginning. It's not dropping that, and I don't know why, so I will News.
I think if you click from beginning,
I've hit that. I've done that one. Hold on, let me just restart the share. Okay. There.
Yay.
Is it showing now?
we can see it perfect.
You got it.
That's odd. Okay. All right. So back to where we were. I'm just gonna briefly go over some of the information about exemptions, which the Harris Central Appraisal District administers, along with property valuations, and just try to give you a clear idea of what the appraisal district's role is and what it isn't, and how we may be able to help you in terms of making sure you get those exemptions cleared up, the importance of making sure you get that the property that's in question has all the appropriate exemptions or does not have exemptions, which is not entitled to, because that can result in some issues down the road. So if you will just kind of go with me, I'm trying to, okay. Here we go. Property taxes. Just a quick background on property taxes to know where we made that transition as for this piece of business that needs to be taken care of when you're dealing with clearing title on inherited property. The appraisal district. So what are we? And why do property taxes play a role in it? Mainly because every homeowner has to pay those, and they support the critical local services within our community. Property taxes tend to play an outsized role in Texas, primarily because there is no state income tax. People like to say, if you move to Texas, they don't have a state income tax. But what we do have are property taxes. And because of the state income tax, the absence of a state income tax, they can sometimes play an outsized role as taxes. They're used, what are they used for? To provide, pay for local schools. They pay for police and fire protection, roads, and that sort of thing. It's also important to remember that property tax laws that each appraisal district has to abide by originate with the Texas state legislature. And then the one agency that typically has oversight in the state over central appraisal districts, of which there is one in each and every county in Texas, that agency, that state agency, is the Texas Comptroller. So central appraisal districts, our primary function is to value all property, appraise all property, county, residential, commercial, agricultural, industrial, as well as something called business personal property. But specifically here, we're talking about residential property. We are required to value that each year at 100% of the market value for that year. And it's done as of January the 1st of each year. So what that means is a lot of things that appraisal districts do are based on the condition of the property as of January the 1st of each year. So that's kind of important to remember when there may be something like, you say you have a fire and some of the property is destroyed, perhaps a room is destroyed. Of course, it decreases the value for that property. However, if it happened after January the 1st, the value is not really going to change until the following January the 1st, if you have not had an opportunity to correct or make repairs to the property. The other thing that HCAD does is that we administer exemptions, and that's one of the reasons we are here talking about the appraisal district today. The other main function that we play in the whole property tax process is that we certify the appraisal rolls. What this does is it allows each taxing jurisdiction, that's your city government, your county government, school district, it allows them to set their tax rates according to what the appraisal roll is in each state. I do want to also mention to you all that Oh, I'm sorry, the slides are not changing. I'm not sure why that is. Have they changed now by any chance?
No, they're not changing.
They're not changing.
No. Do you see it on the bottom like a arrow?
Yeah,
No.
it does.
Mm.
I do apologize. Let's see. Again. Always. Diana, I just sent them to you, just in case. I can't seem to get this.
Did you send it today?
That way, if push comes to shove, you can change them for me.
Could you please send it?
Yes, you just now get it?
Mm-hmm. Yeah, because you didn't send it, right?
I did send it.
Oh, you did?
Yeah.
Um,
Okay, how is that? Is that showing? No. It's on my screen, but
okay, I just received it.
okay.
Okay, it's opening. Okay. Is this one, what slide you were?
If you will go to slide, let's go to slide 3. Okay, and all right, so as I mentioned before, you're up there now. As I mentioned before, the central appraisal districts, we administer all of the exemptions. So that's what we're going to talk about today. We can go to the next slide. In that, then we will go, wanted to have just, I mentioned about January the 1st, wanted to talk, mention also about some of the important dates as it relates to the appraisal calendar. I mentioned January the 1st as being the date of appraisal, and usually that's when changes to property take place or have a significant change in value. May 15th, for those of you who receive value notices on your property from HCAD, which is everyone once a year, is the protest deadline. Should you disagree with that value notice, you have 30 days from the date of the notice, or usually May 15th, to file a protest. Then, of course, the things that the appraisal district does actually result are performed prior to the October-November period, when the taxing jurisdictions mail out the tax bills. And of course, the tax bills are due on February the 1st. Next slide, please. And we'll go to the next slide. And so a little bit of background about appraisal districts is that we are required to be at 100% of market value. And I mentioned some of these things before. Here in Harris County, we are responsible for 1.9 million parcels of land, and we serve approximately 500 taxing jurisdictions in Harris County. Now, you, as a homeowner, may only be taxed by assessed taxes by about 4 or 5 of them, but it sort of depends on where you live, the different jurisdictions that you pay to. You're all going to pay to Harris County because that's countywide. Depending on the municipality that you live in or MUD district, you're going to receive, you're going to be taxed by different jurisdictions. Next slide, please. And we'll go to the next slide, and that's going to be, this is just a copy of what you received. I mentioned earlier about the appraisal value notice. These are going to come in the mail to each year to the property owner. Now, for a deceased person, if that person has, if the records have not been changed, then that annual value notice will typically continue to go to that address. If it comes back, we may attempt to contact and verify that that person is still living there, but typically this is what the annual value notice looks like each year. It gives you the appraised as well as the market value. And so you're able to look at that, and that's how that's the beginning process for property taxation. And the next slide, we'll go on to the next slide. While the slide is changing, I did also want to mention, and I apologize for not doing it sooner, that my colleague Donna Pensick, who's with our information bank, eBank, is on the call. She's in the chat room. So if you have any specific questions, feel free to type those in. Donna will be happy to answer them. And then once I'm done with the presentation, I'll be happy to answer any as well. So I wanted you all to take a look at this because this is often misunderstood in terms of when you receive that, when that valuation notice comes to a home. It's important to remember there are two values on there, the appraised value and there's the market value. The market value is what HCAD determines each year, and that's the value at which, based on the evidence and market trends that we have, that's the value at which a property would sell to for a willing buyer on the open market. And so that's HCAD's primary role, to establish that annual market value. The appraised value is the value that's used in calculating your tax bill. It might be the same as the market value, but it may be lower. In other words, it may not be as much because of something called a 10% appraisal cap. And that's for properties with homestead exemptions. And that's sort of a nice segue into where we're going to be talking about exemptions and that process. They can be a little confusing there. But remember, the appraised value is what the taxes will be based on. The market value is what your home would most likely sell for. And there can be a difference in those. And the next slide, as we go to the next slide, I just wanted to also mention that you have the opportunity when you get that valuation notice to, if you disagree with HCAD's market value, you have the opportunity to file something called a protest, or it's known as a protest or an appeal. And you have a number of ways to do it, and have a number of opportunities to be heard. I'm not going to go into too much of this right now because of the protest process, because that is something that generally occurs from April through July. We will have within the AMOS program beginning in late March and April and through May, we're going to have special workshops that we're going to focus specifically on how the protest process works. And for people that may be interested in protesting their property, we're going to provide you with a lot of information. We'll have some of our appraisers on the presentation, along with our valuation analysts and exemptions folks to help walk you through the process of protesting, should you want to do that. And let's go to the next slide. So today we're going to just concentrate mainly on exemptions to sort of fit in with what Lisa and her presentation is all about. So what are exemptions, and what are they, and how do they save you money, and exactly how can I get them? As I said, they're administered by HCAD, and they basically exempt a portion of your property's value from taxation. Basically, it's a discount on your property taxes. And then once that appraised value is factored in, that's what is going to be used by the taxing authorities. in calculating your bills. And in the next slide, we're going to talk a little bit about some of the more common exemptions. If we could move on to the next slide. It will be, again, I talked about them excluding part of your property from taxation. And what are the most common ones that you're going to find with people who own their homes? It's going to be the general resident homestead exemption, which the over 65 exemption, which is sort of an add-on to the general resident homestead exemption. And then there's some other ones called the opportunities called the over 55 surviving spouse, the disability exemption. There are there's a disabled veterans exemption, as well as some other service-related exemptions. So let's dive into those real quickly. And with the next slide, we're going to talk about the general resident homestead exemption. This one, if you own and occupy your home as your primary residence, you must own it, then you are provided with a number of exemptions, which include a 10% appraisal. That's not really an exemption, but in addition to the exemptions, you're provided something called a 10% appraisal increase cap, which means should you be living in one of these communities, and we all hear about those communities where property values are really hot. Maybe there are investors moving in that are looking to buy up the property. Maybe it's just a popular area, or maybe it's simply the cost of real estate as it continues to increase each year. But when you have property and your value and you have your exemption and your value and the value increases more than 10%, with that general resident homestead exemption, you are going to be protected from major increases, because it will never be able to increase higher than 10% in any given year. So that's important to have to protect you from property values that may be soaring, which they sometimes do. The other thing you're going to get is $100,000 off your initial value when your school taxes are calculated. So if your home's worth $300,000, your taxes are only going to be calculated on $200,000 for the school tax, for your school taxes. There are other exemptions that are offered by various jurisdictions. City of Houston offers 20% on general resident homestead exemption, and even more generous ones for over 65, which representatives, my friends from the tax office, are going to talk about shortly. And just sort of depends. The exemptions often depend on where you live, the city, the county, whether you live in a particular district or not. And so on the next slide, we're going to talk about additionally the let's move to the next slide, and the over 65 and disability exemption. It's important to remember that the over 65 and disability exemption, number one, they're kind of the same thing. But the over 65 is one that a person who already has the general resident homestead exemption should apply for the year they turn 65, because it adds some additional benefits to additional exemptions and savings to your property taxes. You qualify for that for the entire year that a person turns 65. So if they turn 65 December 31st of 2024, they can actually go back and get that exemption for 2024. The disability exemption, pretty much the same as the over 65 exemption, and that's for people who qualified as disabled through Social Security, or they can also, if they don't receive Social Security and they're disabled, then they can also provide a physician statement. HCAT has information about that in order to get that disability exemption. So here's some of the additional benefits of these two exemptions. They get a school tax ceiling freeze, meaning the school taxes the year that they turn 65, they freeze at that amount. They can never pay more than what that amount that they paid that year. They can always pay less if the value drops below that, and the values can be reset. The only time they will pay more is if they do something where they do a major upgrade to the property. And we're not talking about general maintenance. We're talking about things like maybe you put a tennis court in the backyard, or they've added a swimming pool, or they've added square footage, a spare room, a sunroom, or whatever. In that case, they've added additional value to the home, so the school tax ceiling would need to be reset based on that higher value. But they still would maintain some type of ceiling, but it would be reset higher because of the added value. These exemptions, you also get the same exemptions that you already had with the general resident homestead, and you're also eligible for something called a tax deferral, and you can pay in installments. You can pay your taxes in installments without penalties. Tax office will talk about that in a minute. There may be other additional exemptions that certain jurisdictions will grant to property owners over 65. Again, that just depends on where you live in the county. And the next slide we'll go to is one more. Let's move over to the over 55. And this is just simply that if you and your spouse had a home where the spouse turned 65 before you did, and then that spouse unfortunately passes away, as long as you are 55, you're going to be able to continue all of those exemptions. So those exemptions all stay in place. Oftentimes, the longer you have the exemptions, the less you're paying. So that's important. As long as the surviving spouse was 55 years of age or older on the date of their spouse's death, they continue to receive all of those benefits. You will turn to the next slide, please. The one thing I wanted to explain here is something called when you apply for your exemptions. There are a lot of folks out there who may live in an heir property where they're living in the property, and there may be other heirs, either living in the property or living someplace else. As long as that heir is typically, you cannot receive your exemptions unless you are the owner of the property. However, because this situation allows the individual who's living in the property to continue living there, and they also are paying the bills, they're taking care of the property, they will have the opportunity to apply for the exemption under something called the heirship exemption. That's on our general resident homestead exemption application, section 3. You can identify yourself as an heir property owner. And what happens then is that we can take you through a process. You can provide some additional information that will, such as an affidavit of ownership, something I think Lisa mentioned several times is something that was needed. We would need death certificates from the prior owner, and any court record of citations that you might have, as well as a copy of the most recent utility bill from the property. And that's just to ensure the property is being lived in. So with that information, we can help that heir get the full exemption, and it would not affect the ownership rights of any of the other heirs. It just simply allows that heir to take advantage of those exemptions. And let's go to the next slide. And again on that heirship exemption, because I know a lot of people tend to listen intently because they may be subject to something like that. That may be the case for them, or they may know someone in their community who has a similar concern. If there are any questions about that heirship exemption, I recommend to please call HCAD, someone in our exemptions department, or you can email us through eBank. We'll be more than happy to help you, walk you through that process. Now, one thing I wanted to mention before and the reason we talk so much about exemptions is because as you're trying to clear property, some of these issues may crop up, particularly when someone has lived in a property for a while and that person did not change the exemptions. Because it's important to remember that exemptions are based on the person, the qualifications of the person living in the home. So if someone is receiving an over 65 exemption, you may look at the paperwork and go, oh, the taxes are very low on this property. But once someone else moves in, they are not eligible for those. And therefore they have to make sure they notify the appraisal district. They'll need to make sure that that the deed is available, that, in other words, it's been probated, or some other additional information has been provided, because there's always keep in mind that if you're living in that home and you're not paying the taxes that you're not paying the taxes that you should be paying, because there's information is incorrect in terms of what the exemptions are, then, excuse me, then you could foreseeably have to go back and pay several years of back taxes, because that information was never corrected on the tax rolls. So that's why it's so important to keep in mind, be conscious of making sure that once you move into a property, an inherited property or as such, that the title and ownership is carried through in a timely manner. So let's go to the next slide. Well, before we move on, I say exemptions versus deferrals because I just want to put a bookmark in the fact you're going to hear a little bit about something called a deferral, which I mentioned you would be eligible for over 65, versus an exemption. A lot of people have the mistaken idea that exemptions are something that you get and doesn't cost you anything. They are for free. The exemption is a discount on your property taxes based on your qualifications, your age, the fact that it's your primary residence. A deferral is something that you would apply for separately to defer your taxes. And defer taxes means you simply are deferring them, and they will come due at some point. So please don't get the two mixed up. We've heard some senior folks say that I don't want that over 65 exemption because I don't want my kids to have to pay it back. That's not, they're not referring to exemptions. You do not pay that back. It is the deferral that you pay back. However, if your kids are living if somebody moves into a home where there are exemptions that have not been removed, they could foreseeably be responsible for paying the difference in what they should have been paying in property taxes. So just something to keep in mind, because it can tend to be confusing. And if we go to the next slide, just how do you apply for exemptions? Simply, you can mail in the paper form that we have. We have forms online. We have a mobile app, or you can simply email the form in. Go to our website, pull it down, fill it out. They are, in most cases, most of our forms are fillable, and you can submit it that way. We do ask that you make sure you try to submit everything at once. We have clear instructions on our website on how to do that. What it does is, if you don't send in all the information, then it can delay your processing. So you want to send everything in at once. If you're sending, you do need that driver's license, please make sure you send the driver's license in. That's usually the one thing that typically once you have all your paperwork in order, sending that driver's license in is important, because that driver's license has to, the address on the driver's license will need to match the address of the property. Once your exemption has been approved and applied, you're going to be notified by HCAD. Also, if you want to go out online, anyone who goes out online to fill out the form, we do have actually a how-to video that you can actually, play along as you fill out the form. So we do our best to try to make that process easy and understandable for everyone. I did want to mention too, sometimes you might get something in the mail that says, we can get you a designation of homestead for a fee. Read those carefully, because sometimes they're just saying, hey, they can apply for your homestead exemption for you, and they will charge you a fee for it. Please know that acquiring your exemptions are free, absolutely free to the property owner. There is no cost when you go and fill out that form. Those forms provide the additional information and send it back to HCAD. And let's go to the next slide. I think we have one more. So what you're looking at here is a copy of a card that we send out annually, usually in December, early January. And what it is it's your exemptions confirmation card. It's going to say on it the property owner's name, and it's also going to say for the upcoming tax year, for the previous tax year you had homestead exemptions, and it's going to name the ones that you have, and it'll say they're going to be automatically renewed unless something has changed. You would need to contact HCAD to let us know that that has changed. In fact, you are required to do so by law. And so if you receive these, your regular homeowner, you received nothing has changed, then don't worry about it. You can just kind of throw that in the drawer. If you get it and something has changed, like it's got a relative's name on it to a home that you just moved into because you inherited it, you want to check those exemptions to make sure that that they're the ones that you would qualify for as well. If it's an elderly resident over 65 and you're in your 30s or 40s, then you're obviously not qualified for those over 65 exemptions. So that's when that's when you need to make sure that that gets corrected. Also, these forms are not, when they're mailed out, they are not allowed to be forwarded to another address. So if the property owner is not there to receive it, that card is going to come back to HCAD. We are going to do some checking to see if that property owner is still living in the home, but more than likely, if we can't find out any additional information, that's when the exemption may be canceled. So you just want to make sure you kind of look out for this card each year. And then the next slide, I believe we're getting close to the end real quickly. If we can, that's a copy of our website at www.hcad.org. And then finally, this last slide is going to include our contact information. And if you can move it to that one, we're out on the Northwest Freeway at the Hollister Tidwell exit. And our Joan phone number, as you can see, if anybody that may want to quickly take a photo of that. Website is www.hcad.org. And then you can also go online and contact us at this following address and put in a request form. And we will be more than happy to get back with you. That is all of my presentation. Again, was a lot of information, so I'll be around along with Donna to help answer any questions that you may have about it. Thank you so very much for listening. And have a great afternoon, and I will turn it over to my colleague down at the tax office, Shay.
Hi, everyone. Good afternoon. I am back. Thank you so much, Ms. Mabel. I appreciate all your information. I know that exemptions are a lot for people to wrap their heads around, so, we are here to answer your questions. I'm going to go ahead and start my presentation here on my end. Just bear with me for a second. All right. Can everyone see the screen okay? Everything's good?
Yes.
Perfect. Thank you. All right, everyone. My name is Shay Pinkowski. If you weren't here earlier when I introduced myself, I am with the office of Annette Ramirez with the Harris County Tax Assessor Collector's Office, and I'm going to be talking about property taxes as well as what you can do to assist our taxpayers in making sure that those taxes get paid, and hopefully answering some questions for you if you have any for me. So let's go ahead and get started. Just as a general overview, the Harris County Tax Office collects approximately 1.9 million tax accounts that collects the amount of $8.2 billion in property taxes every year. So we're a very large department. We're a very large taxing collector assessor, and we collect for things such as your Harris County taxes, your City of Houston taxes, Houston ISD, and a few other school districts, along with your Harris County flood control. So a lot of the taxes that you pay more often than not will end up coming to our office, whereas you'll have a couple of other bills on occasion, depending on where you're located, that might be for other offices, like Pasadena ISD is one of them off the top of my head, along with a couple of MUDs. So utility districts can be collected elsewhere, but we do collect for about 82 taxing jurisdictions, so our bill is usually pretty lengthy. Just as a general overview, tax bills are collected by taking your property value, which is provided to us by the appraisal district, and then multiplying that by the tax rates, which are determined every year by the jurisdictions that we collect for. And using that calculation, we result in your tax bill, which is what we send out every year, usually towards the end of October, middle of November, and is due at the end of January every year. We've had a couple of changes recently, as we do every year. Harris County has increased the over 65 and disabled exemption from $275,000 to $320,000, which is pretty great, especially for those folks who are over 65 or disabled. It does help with your tax bills and reducing that amount that you pay. City of Houston has increased their tax exemption as well for over 65 and disabled persons and their homestead, and that is gone from 160,000 to 260,000. And then, as a few of you have already seen on your bill, the general homestead exemption for property taxes was increased from 25,000 to 100,000, which helped a lot of you in your ISD bill specifically. Homestead exemptions are available for property owners from a prorated start date now, as opposed to prior before when you had to live there for an entire year from January 1 all the way through. They're now allowing you to have a prorated start, meaning that if you move into the property sometime in the middle of the year, you would have that exemption applicable for that percentage of the year starting when you moved in, as opposed to having to wait for the full first year. There is a limit that is on property appraisal increase, which is that cap, and for non-residential properties over $5 million. And that's not something that was on there prior, but we'll get a little bit further into that later. For those who prefer to use visual means of understanding, this is just a really quick chart and demographic of the total that you would pay without any exemptions, no homestead, no over 65 or anything else in addition to that, based on a property with a value of $325,000 for Harris County. So Harris County allows for 20% of the homestead, and then that would be that second chart there in the center of the page. So on a general bill without any exemptions present, it would be approximately $7,479 for a property of that value. With a homestead exemption, that gets reduced by about almost $2,000. So it would result in a tax bill of $5,565. And once you get into that over 65 and disabled exemptions, that's when you start seeing a really large difference in the amount that you would pay for your property taxes. You start seeing that big jump from, $7,479 to $2,431. And we do like to encourage people, if they are over 65 and that is their homestead, to go and apply for that exemption. A lot of folks get worried that it might, come back and their heirs will have to come in and pay it later, but that's not the case with exemptions. Exemptions are applied and they stay on the property so long as the person who has those exemptions applied to them lives in that property. So it's not something you have to worry about once you pass away. The tax freeze and tax deferral is usually where that confusion starts to set in. So the tax freeze is known as a tax ceiling or a tax freeze, and really what it is a tax limitation. And what it means is it limits the amount that your school taxes, that the taxes collected for your ISD can collect. And that is applicable to homeowners over the age of 65 who are disabled or disabled veterans or their surviving spouses of disabled veterans over 55 years. And that tax freeze limits the amount that you pay for your school taxes, but that is not applicable if once the person has passed away. So or is no longer living in that home. If they decide to sell or gift it to an heir, that tax freeze does not remain on the property if that person is not living there. The tax deferral is what folks believe the exemption and confuse the exemption to be. That tax deferral is something of almost like an insurance policy. It assists you in making and having options when you're when you have the possibility of not being able to pay your bill on time. So you would still receive your tax bills as always. You would still see the amount that you would owe. The exemptions would still be removed from it, but that tax deferral postpones your payment of taxes, meaning that if you are unable to make your tax payment timely as you normally would have, it postpones your taxes. So you would not be in trouble with our attorneys. You would not receive um, collection notices from them in reference to this property if the deferral is active. Um, you receive a 5% interest per year on unpaid balances, meaning that if you're able to pay a portion of it, you receive interest in the amount of 5% for the full year, as opposed to our usual, 7% in February and then 9% in March and onward until it's capped off. The deferral ends upon the sale or the change of a property or the change of ownership, meaning that if the person sells the property that was over 65 and they sell the property, it's no longer applicable, and the taxes that were due at that point must be paid in order to pay it in full. It delays your tax payment. It doesn't cancel your tax payment, meaning you can have a deferral on a $0 bill, meaning that if you receive your tax bill and it has a zero amount due, but you have a deferral on the account, that tax bill is $0. It means you would not have a bill for that year regardless. But that bill does change every year, so make sure that if you do have a deferral on your account, that you just stay aware of what your tax bill is every year to make sure that there aren't any amounts becoming due. Our office does offer payment plans in the case of those who have the homestead but are not over 65 or do not have a homestead and would like to create a payment arrangement for your property taxes. We have flexible time periods in which you can do so. For property owners who have the homestead, you can have it for 12 to 36 months, beginning as early as February 1st. And this is in order to avoid collection efforts that get tacked on at later times once the account goes to collections. This helps avoid that by promising to create and and keep up with your payment arrangements. You can pay it off early. So if you anticipate being able to pay it off within 6 months as opposed to 12, you are able to do so. It does not have any consequence. As a matter of fact, you pay off with a little bit less penalty and interest whenever it's not a homestead. There are no attorney's fees if your contract begins prior to our law firm beginning collections, and it can help avoid foreclosure efforts. So it is something to be aware of. It is something to be mindful of, especially if the tax bill season is coming up and you recognize that you may not be able to pay off your taxes in full. That's totally understandable, but we are here to help and we are here to assist in making sure that everyone has a way of making those tax payments without dipping further into, financial troubles because of it. For our over 65 taxpayers, as well as our disabled owners and disabled veterans, along with their surviving spouses, we have something called a quarterly payment plan, which assists in those who have fixed income or who are aware that they will not be able to make the full entire payment by the end of January. You have the opportunity to split that payment into 4 equal installments due over the course of the first couple of months of the year. So if we do first payment is January, the second in March, with the third in May and the fourth in June. On the quarterly payment plan, you do not pay penalty or interest so long as you pay timely. This is more in order to be able to extend the ability for you to make those payments timely and to also assist you in making those payments without as much financial hardship as you might have had otherwise. Your account does have to have the homestead and over 65 or disabled homeowner or disabled veteran surviving spouse on the account as your exemption status. So in order for us to be able to apply that quarterly payment plan to the account, it does have to be completed with the appraisal district first. So just keep that in mind. But if you know that you have your homestead exemption along with your over 65 disabled owner, disabled veteran, or if you're a surviving spouse, and you know that you're not going to be able to complete those payments, please feel free to reach out to us. We are more than happy to help you in getting that started. For our payment plans, we do have the information here. Um, as I mentioned before, this helps avoid attorney collection fees along with foreclosures, so long as your payment plan is active and you're making your monthly payments. That helps protect you as the property owner as you're continuing to make these plans. The homestead and homestead property payment plans are a little bit different from other payment plans, and other would encompass for business personal property, non-homesteaded property, and things of that nature. Homesteaded plans begin on properties who have the homestead exemption placed onto them. As I mentioned before, it can be anywhere from 12 to 36 months, and the terms include a 1% interest per month plus the initial penalty for the month in which you begin your plan. So, in an example for February, it would be at a 7% with the 1% it would be the 5% penalty with a 1% interest per month to make that payment. Um, it can be used for current and prior years of taxes, and all of our payment plans are due at the end of each month. So February is a bit short this year, it's 28 days. So you would have to make that payment prior to the end of February. For our other payment plans, for non-residents, for business and commercial, for personal property, they are still able to do 12 to 36 months this year. Next year, it would be for 12 months and it would not be able to be extended. You do still have your property taxes collected with the usual incurred penalty and interest fees, but as I mentioned before, it is mostly to assist with avoiding attorney's fees, attorney's collections, and foreclosure actions on your property. And as mentioned before, they would also be due at the end of each month. I have our contact information here on the screen. If you have the ability to screenshot, we'll also be posting it onto the chat later on. Should anyone like to reach out to us for further assistance, or if you have questions, please feel free to reach out to us. We're more than happy to help. And if you have any questions that are delicate in nature, or if you'd prefer to not give your information, I do recommend that you give us a call and we'll be able to assist you as best we can. But that is it on my presentation. I believe that someone is going to start taking questions here in a bit.
I've got a couple questions to answer from emails, and I wanted to quickly show you where our guide is for creating your own transfer on death deed. So I'm going to share my screen real quickly. This is our website, Texas Law Help, and I searched for Todd, transfer on death deed. And this, my screen looks a little different because I have the right to edit the website, but you would see this part. And this is our guide on how to create a transfer on death deed. If you go to instructions and form, we have detailed instructions that will walk you through how to prepare the deed. And just as a side note, we do have attorneys available to chat Monday through Thursday. It's supposed to be 10 to 2. I guess they're taking a few extra chats today. Whenever you see this green button with the need legal help, that usually means that there's someone available to chat. Now I'm gonna switch over to the email to see what questions people had. Now, title transfer and clear title is, those are a little bit too vague. So if somebody wants to unmute themselves and ask, they can. I'm going to go ahead and answer a couple of other questions real quick. Someone has a TOD filed and wants to know, what is the process after the new owners take possession? If someone inherits a house through a transfer on death deed, they need to file what is called an affidavit of death. That is something also on our website. So you would complete that form. You would take an affidavit of death, the death certificate, and your ID to the county clerk's office in the county where the property is located. File that affidavit of debt, and the house will be transferred into your name. Affidavit of heirship is a form that you can find on our website with instructions on how to fill it out. Now, someone had a question about reverse mortgages. Any debts for land, so that would be reverse mortgages, traditional mortgages, home improvement loans, those stay with the land. So if you inherit property that has an unpaid loan of any type, you are responsible for that loan. Reverse mortgages are due, I believe, 30 days within the date of death. You can, with an attorney, delay that process and buy some time, but you will eventually have to pay for it. And delaying is not necessarily a benefit because that interest is going to add up. Attorney's fees are going to add up. But if there's a reverse mortgage, you're going to have to pay it if you inherit that property. And I will, someone else, and this would be a Shay or Mabel question, wanted to know about overdue taxes on inherited property.
Give me a second. There we go. Okay, so overdue taxes on inherited property, meaning that the person who owned the property previously has passed away, leaving taxes behind. If the person who is inheriting the property received it and the taxes had been unpaid, if they had been deferred previously, it's a little different of a situation. But either way, the property taxes are the responsibility of the new owner or the person receiving the property. In the case of deferred taxes, with that 5% interest rate, that is not the norm for interest and penalty due on overdue taxes. Because of the deferral, you have 181 days from the date of notice that the deferral will be removed in order to pay for that amount as it is with the deferral and the over 65 and the homestead as it had been, in order to pay those back taxes due to that deferral being on the account. But after those 181 days, that property is no longer considered a deferral. The penalty and interest fees will be as they would have been without that deferral on the account. So the exemptions would still be on there up until the year in which they pass away or transfer the property over. But they would have your penalty and interest as it would be normally, which is that 5% plus interest, so 7% starting February, then March with 9 onward and onward and onward. So you have that 181 days to make that payment for the penalty and interest at the 5% rate for the deferral if it's active. Otherwise, or rather, either way, the property taxes would be due from the new owner of that property. I
Does
don't know if,
anyone have any questions?
yeah, I was about to say that's kind of a hard process to follow. So if anyone has any questions, now would be a good time if you want to pop them in the chat or I think you had Facebook going on also, if I recall correctly.
Oh, well, I don't have Facebook on, so I'm not sure if we've gotten any
Oh.
questions through there.
All right, seems pretty
I
quiet.
have it open, but I don't see any comment. I will let you know if I see.
Oh, perfect.
Mhm.
Thank you.
But I guess we'll give 5 minutes and see if anybody has questions. Otherwise, we'll give you the rest of your afternoon back.
No problem.
It looks like we've got a quiet group today, so I think we can end this early. Thank you, everybody. I don't know, Diana, if you or Cecile, if you have any updates.
Yes, just a quick reminder to everybody, we're going to be hosting Coffee and Conversation next week on Wednesday the 19th at the Acres Home Multi-Service Center from 10 to 12 in the afternoon. We'll be having guest speakers from the Mayor's Office for People with Disabilities, Waste Management, and some of our AMOS partners will be coming to join us to just share information with the community. If you are interested, please come through. I know you can register. We do have the registration link on our AMOS Instagram, which is just AMOS Houston on Instagram, but you don't need to register necessarily to come to the event. It's open to everybody. So again, we'll have Coffee and Conversation on the 19th at Acres Homes Multi-Service Center from 10 to 12.
Thank you, everybody, for coming. Please share this. Let your friends know we're here the second Thursday of almost every month, and every presentation is slightly different due to our great audience questions.
Thank you all so much for being here.
Thank you all.
Thank you.
Thank you. Have a great day.
Thank you. Have a
Thank
great
you.
day, everyone.
Thank you. Bye-bye, everybody.
Bye.
Bye.
Bye.